In a life estate, two or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. The life tenant has full control of the property during his or her lifetime and has the legal responsibility to maintain the property as well as the right to use it, rent it out, and make improvements to it. When the life tenant dies, the house will not go through probate, since at the life tenant's death the ownership will pass automatically to the holders of the remainder interest. Because the property is not included in the life tenant's probate estate, it can avoid Medicaid estate recovery in states that have not expanded the definition of estate recovery to include non-probate assets. Even if the state does place a lien on the property to recoup Medicaid costs, the lien will be for the value of the life estate, not the full value of the property. If the property is sold, the proceeds are divided up between the life tenant and the remaindermen. The shares are determined based on the life tenant's age at the time. The older the life tenant, the smaller his or her share, and the larger the share of the remaindermen. Be aware that transferring your property and retaining a life estate can trigger a Medicaid penalty period if you apply for Medicaid within 5 years of the transfer. Purchasing a life estate should not result in a transfer penalty if you buy a life estate in someone else's home, pay an appropriate amount for the property, and live in the house for more than a year. If you have any questions regarding life estates or estate planning, contact the experienced attorneys at Heritage Law Office for a free consultation.